Welcome to the channel of Legal Master, where in today's video lecture I would be starting off with the company law, where I have divided into 5 units, and in today's lecture I am going to start with unit 1 and most probably finish it off in this particular lecture, or maybe in more lectures to come if it takes too long to complete in one lecture. So let's start off with the concept of a company. The concept of company or corporation in business is not new, but was dealt with in 4th century BC itself during Arthashastra days. Its shape got revamped over a period according to the needs of business dynamics. Company form of business has certain distinct advantages over other forms of businesses like sole proprietorship or partnership, etc. It includes features such as limited liability, perpetual succession, and etc. After going through this lecture, you would be able to understand the historical development in the evolution of corporate law in India and England, emerging regulatory aspects including Companies Act 2013, besides dealing with characteristics of the company and how it differs from other forms of businesses. Next up is meaning of a company. The word company is derived from Latin word com, with or together, and panis, which means bread, and it originally referred to an association of persons who took their meals together. In the leisurely past, merchants took advantage of festive gatherings to discuss business matters. Nowadays, business matters have become more complicated and cannot be discussed at festive gatherings. Therefore, the company form of organization has assumed greater importance. It denotes a joint stock enterprise in which the capital is contributed by several people. Thus, in popular parlance, a company denotes an association of like minded persons formed for the purpose of carrying on some business or undertaking. A company is a corporate body and a legal person having status and personality distinct and separate from the members constituting it. It is called a body corporate because the persons composing it are made into one body by incorporating it according to the law and clothing it with legal personality. The word corporation is derived from Latin term corpus, which means body. Accordingly, corporation is a legal person created by a process other than natural birth. It is for this reason sometimes called an artificial legal person. As a legal person, a corporation can enjoy many of the rights and incurring many of the liabilities of a natural person. An incorporated company owes its existence either to a special act of parliament or to company law. Public corporations like Life Insurance Corporation of India, SBI, etc., have been brought into existence by special acts of parliament, whereas companies like Tata Steel Limited, Reliance Industries Limited, etc., have been formed under the company law, that is, Companies Act 1956, which is being replaced by the Companies Act 2013. Next up is the definition of company. In the legal sense, a company is an association of both natural and artificial persons and is incorporated under the existing law of a country. In terms of the Companies Act 2013, Act number 18 of 2013, a company means a company incorporated under this act or under any previous company law. Section 2, Clause 2. In common law, a company is a legal person or legal entity separate from and capable of surviving beyond the lives of its member. However, an association formed not for profit also acquires a corporate character and falls within the meaning of a company by reason of a license issued under Section 8, Clause 1 of the Act. A company is not merely a legal institution, it is rather a legal device for the attainment of the social and economic end. It is therefore a combined political, social, economic, and legal institution. Thus, the term company has been described in many ways. It is a means of cooperation and organization in the conduct of an enterprise. It is an intricate, centralized economic and administrative structure run by professional managers who hire capital from the investors. Lord Justice Lindley has defined a company as an association of many persons who contribute money or money's worth to common stock and employ it in some trade or business, and who share the profit and loss arising therefrom. The common stock so contributed is denoted in money and in the capital of the company. The persons who contributed in it or from it or to whom it belongs are called members. The proportion of capital to which each member is entitled is his share. The shares are always transferable, although the right to transfer them may be restricted. From the foregoing discussion, a company has its own corporate and legal personality, distinct which is separate from its member. A brief description of the various attributes is given here to explain the nature and characteristics of the company as a corporate body. Coming to the historical development of company, as we all know that India has drawn a lot of legislation from England. Similarly, in the case of company law, India enacted company law based on the company law enacted in England. The three phases which influence the company legislations may be divided as: first, colonization era; second, period after World War II; and third, the opening up of Indian markets in the year 1990. Legislation enacted. In the year 1850, the first company enactment for the registration of the Joint Stock Company was introduced in India. This enactment, as mentioned before, was based upon the English Companies Act 1844. Later in the year 1857, the concept of limited liability was recognized in the company's legislation, but the said limited liability was not extended to the banking company. The concept of limited liability into Companies Act was introduced earlier in the English Companies Act of 1856. But by the year of 1858, the concept of limited liability was extended to banking company even in India. In the year 1866, Companies Act was yet again passed for consolidating and amending the laws relating to incorporation, regulation and winding up of trading companies and other associations. This act was based upon the Companies Act 1862 of England. This act was recast in the year 1882 and was in use until 1913. In the year 1913, another Companies Act was enacted based upon English Companies Consolidation Act 1908. Companies Act of 1913 was amended in the year 1914, 1915, 1920, 1926, 1930 and 1932. But the major amendment to the Companies Act of 1930 was made in the year 1936. This amendment was based upon the English Companies Act 1929. The Act of 1930 regulated the Indian Business Company until 1956. By the end of 1950, Bhabha Committee was set up under the chairmanship of H. C. Bhabha for the defense of Indian Companies Act with reference to the development of Indian trade and industry. The committee submitted its report in 1952. This report of Bhabha Committee was accepted into Companies Amendment Act of 1956. This legislation was made keeping in mind the English legislation of Companies Act in 1948. Next up is the Act of 1956. The period of Second World War and post-war years witnessed an upsurge of industrial and commercial activity on an unprecedented scale in India, and large profits were made by businessmen through incorporated companies. The Government of India took up the revision of company law immediately after the termination of last war. Two company lawyers, one from Bombay and the other from Madras, were successfully appointed to advise government on the broad lines on which the Companies Act 1913 should be revised and recast in the light of the experience gained during the war years. Their reports were considered by government and a memorandum embodying its tentative views was circulated towards the end of 1949 for eliciting an opinion. On 28 October 1950, the Government of India appointed a committee of 12 members representing various interests under the chairmanship of Shri H. C. Bhabha to go into the entire question of the revision of Companies Act with particular significance to the development of trade and industry of India. This committee, popularly known as the Bhabha Committee, submitted its report in March 1952, recommending comprehensive changes in the Companies Act of 1913. The report of the Bhabha Committee was again the subject of discussion and comment by chambers of commerce, trade associations, professional bodies, leading industrialists, shareholders, and representatives of labor. The bill, which eventually emerged as the Companies Act 1956, was introduced in Parliament on 2nd September 1953. It was a comprehensive and consolidating as well as amending piece of legislation. The bill was referred to a joint committee of both houses of Parliament in May 1954. The joint committee submitted its report in May 1955, making some material amendments to the bill. The bill, as amended by joint committee, underwent some other amendments in Parliament and was passed in November 1955. The new Companies Act of 1956 came into force from 1st April 1956. Next up is major changes brought forth by the Companies Act 1956, which stated the promotion and growth of companies, capital structure of the companies, company meetings and procedures, company accounts and its presentation, and powers and duties of the auditors of the company, inspection and investigations of the affairs of the company, the constitution of the board of directors, powers and functions of directors, managing directors and managers, and administration of the company law. Next up is the amendments in the Companies Act 1956. Any other legislation, various amendments were made to the Companies Act 1956 as explained. The timeline of amendments go as first in 1960, then in 1962, 63, 64, 65, 66, 67, then in 69, then in 1974, 77, 85, 88, and 1991 during the period of LPG reforms. Opening of the market gates to the globe 1990. The era of liberalization, privatization, and globalization saw the anachronistic companies legislation made in time of closed market and hence inadequate to handle the global entry. This non-conducive legislation would have obstructed the Indian corporate sector. In pursuance to this necessity, the Companies Bill 1993 was formed, but was later withdrawn. The Depository Act 1996 was introduced in India, and later a working group was constituted to rewrite the Companies Act 1956. In pursuance to above made effort, the Companies Bill 1997 was introduced in Rajya Sabha on August 14, 1997 in order to replace the prior legislation. The President of India promulgated the Companies Amendment Ordinance 1998 on October 31, 1998. But this promulgated the Companies Amendment Ordinance 1998 was soon replaced by the Companies Amendment Act 1999. The objectives of this Amendment Act were to surge the capital market by boosting the morale of national business houses and fostering the FITs and foreign direct investments in the country. The changes brought by the Companies Amendment Act 1999 were: a facility was introduced to allow the corporate sector to buy back companies' own share. Provisions relating to investments and loans were liberalized and rationalized. Requirement of prior approval of the central government on investment decisions was done away with the companies, and companies were allowed to issue sweat equity in lieu of intellectual property. The compliance of Indian accounting standard was made mandatory, and the National Committee on Accounting Standard was also incorporated. The benefit of the investors was looked into by setting up the Investor Education and Protection Fund, and introduction of the nomination to shareholders, debenture holders, etc. was also done. Later, the Companies Amendment Act 2 was enacted, which was followed by the Companies Amendment Act 2001, wherein the Section 77A was introduced in relation to buyback of the shares. This amendment allowed the board of directors to buy back the shares up to 10% of the paid up capital, and free reserves provided not more than one such buyback is made during the period of 365 days. Then the Companies Amendment Act 2002 was enacted, which was followed by Companies Second Amendment Act 2002. The First Amendment introduced the setting up and regulation of corporate as body corporate under Companies Act 1956 to be called producer companies. The Second Amendment was to expedite the winding up process of the companies, to facilitate rehabilitation of the sick companies and protection of workers' interests. The Companies Amendment Act 2006 was brought into force on 1st November 2006, wherein it introduced the Director Identification Number, that is DIN, and also introduced electronic filing of various returns and forms. Then comes up the new enactment of the new society. The Companies Act 2013 replaced the Companies Act 1956. The legislators introduced ideas of the likes of corporate social responsibility, that is CSR, class action suits, fixed term for the independent directors. The provision of raising money from the public was made little stringent. Prohibition on insider trading by company directors or key managerial personnel by declaring such activities as a criminal offense. It permitted shareholder agreements providing for the right of first offer or right of first refusal even in the case of public companies. The Companies Amendment Act 2015, it received the presidential assent on May 2015 and became operative on 29th May 2015. It is designed to address the issues of stakeholders such as chartered accountants and other professionals. Coming up with the key amendments brought in by the Companies Amendment Act 2015 may be explained as follows. No minimum paid out share capital. No minimum paid out share capital requirements will now apply for incorporating private as well as public companies in India. Relaxation in relation to related party transaction. In the case of related party transactions which require stakeholders' approval, relaxation has been given wherein earlier required special resolution has been replaced by the ordinary resolution. Next up, inspection of the resolution filed with the registrar. This act has limited public access of such resolutions relating mainly to the strategic business matters. Such documents will no longer be available for the public to review or permitted to take copy of. Next up is Common Seal optional. Under the Act of 2013, it was required to affix common seal on certain documents, but now after the Act of 2015, the use of the common seal has been made optional, although the common seal is one of the integral characteristics of a company. Next, violations of acceptance of deposits. Companies Act of 2013 provisions in relation to the acceptance, renewal, or repayment of deposits. However, no specific penalty prescribed for the new compliance with the relevant provision, that is Section 13 and Section 76. A new Section 76A has been introduced for the non-compliances. The defaulting company will be liable for a minimum fine of 1 crore rupees and maximum amount of 100 crore rupees in addition to the amount of deposit or part thereof along with interest. Coming to the dividend part, the Companies Act 2015 has introduced a proviso which states that a company must set off the losses and depreciation carried over from past years against the profits of the company before declaring dividend for a financial years. The Companies Amendment Act 2017. The Companies Amendment Bill 2016 was intended to be passed by the legislature, but after referring it to the committee, this bill went through a lot of corrections and metamorphosed into the Companies Amendment Bill 2017, which was then passed as the Companies Amendment Act 2017. Coming to the salient features of the amendments brought by this act, which are synergy with SEBI and RBI rules. For the first time, several provisions have been amended to align the Act with various rules and regulations of the SEBI, Security Exchange Board of India, and the RBI, that is Reserve Bank of India. For example, Sections 194 and 195 of the Act, which was dealing with the offence of insider trading and forward dealing, have now been omitted since the SEBI regulations were sufficient to cover all. The instances of such frauds, further disclosures to be made in the prospectus have also been aligned with the SEBI's power to regulate initial public offering, that is IPOs. The definition of debenture has been amended to permit RBI to disqualify certain instruments as debentures. The next up is proportionality of penalties. The quantum of penalty will now be levied taking into consideration the size of the company, nature of business, injury to public interest, nature and gravity of default, repetition of default, etc., which is one of the most appreciated amendments. Two new provisions regarding the determining of the level of punishment have been freshly introduced and lesser penalties for one-person companies and small companies were inserted. Provisions for small companies and penal vigor has been reduced. Placement process made easier in private sector. The placement process is rationalized by doing away separate offer letter details to be kept in the records of the company and hence reducing the number of filings to registrar. The company is not allowed to use money from private placement unless allotment made and the return of the same filed with the registrar. To make sure that an investor are informed, the disclosures are made under explanatory statement as provided in Rule 13, Subclause 2, Subclause D of Companies Share Capital and Debenture Rules 2014, embodied in the private placement application form. Change in definition of private placement is proposed to umbrella all security offers and invitations other than rights. The companies would be allowed to make an offer of multiple security instruments simultaneously. Standards for independent director. Section 149 of the Act deals with the qualifications and disqualifications of independent directors. Subsection 6 provides for various disqualifications for becoming an independent director, one of which is such a person having pecuniary relationship with the company, its holding, subsidiary or associate company, or their promoters or directors. The amendment clarified that pecuniary relationship excluded the remuneration of director having transaction not exceeding 10% of his total income or such amount as may be prescribed. Next up, coming to the Companies Amendment Act 2019. The Companies Amendment Act 2019 received the assent of the President on the 31st July 2019. While introducing the bill in the Lok Sabha, the Honorable Finance and Corporate Affairs Minister Nirmala Sitharaman ji said, the bill seeks to ensure more accountability and better enforcement to strengthen the corporate governance norms and compliance management in corporate sector as enshrined in the Companies Act 2013. In order to review the Companies Act and to gain better compliance, the Government of India constituted a committee in July 2018. The said committee, after taking the opinions of several stakeholders of the company, submitted its report in August 2018. The committee recommended that serious offences must face rigor of law, but technical mistake be given in-house adjudication for speedy redressal. Accordingly, proposal to amend certain provisions of the Companies Act 2013 was made. However, in view of the urgency, the Companies Amendment Ordinance 2018 was promulgated on November 2018. To replace the aforesaid ordinance, the amendment bill was introduced in Lok Sabha and passed, but bill was not taken up in Rajya Sabha. Therefore, to continue the effect of prior ordinance, the President promulgated the Companies Amendment Ordinance 2019 on the 12th day of January 2019 and the Companies Amendment Second Ordinance 2019 on the 21st day of February 2019. Then the Companies Amendment Bill 2019 was passed by both the Houses of Parliament and became the law. The major reforms undertaken by Ordinance of 2018 and 2019 include the following: recategorization of offences which are in the category of compoundable offences to an in-house adjudication framework. However, no change has been made for any of the non-compoundable offences, ensuring compliance of the default made and prescribing deterrent penalties in case of repeated defaults. Delegation and declogging the NCLT by enlarging the jurisdiction of regional director by increasing the pecuniary limits up to which compounding of offences under section 441 of the Act can take place. Vesting in the central government the power to approve the alteration in the financial year of a company under section 2 clause 41. Vesting the central government the power to approve cases of conversion of public companies into private companies so as to reduce the burden on the government and developing the sector. Other reforms include reintroduction of declaration of commencement of business, provision, greater accountability with respect to filing documents related to creation, modification and satisfaction of charges, non-maintenance of registered office to trigger deregistration process, holding of directorships beyond permissible limits to trigger disqualification of such directors. Thank you for watching the video lecture with all your patience, and do not forget subscribing to this channel for more such video lectures of company law. And after that I am going to cover other business laws as well in lecture series, as well as one shot and marathon sessions.